going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky! Got anything to say?
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you guys are having a great day so far. All right, I have got a good one. This is an eviction hearing with a Karen attorney as the tenant. The attorney's being evicted, and let's just say the facts of this case are just out there. And I really hope that not even 10% of these claims are remotely close to being true. If they are, then I'm going to take back the fact that she's a Karen. I'm just saying that from what she's saying, kind of sounds like it. You got to hear it. Also, I've got a bonus at the end of this video. I'll explain that more when that clip happens. There's a reason why I put it at the end, and I'll explain it. But you guys got to hear what's going on in this one. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
We are now going to hear PreTrial Matters for cause 24-00-1120, Yolanda Brammer versus Heather Godwin. Mr. Akhtar, you're here on behalf of plaintiff Brammer.
Yes, Your Honor.
Ms. Godwin, you're representing yourself?
Yes, Your Honor.
But both of you are counsel, so a little bit different than when I get pro se in the typical fashion. All right. Now, I believe we had motions from both sides. Mr. Akhtar, on behalf of Brammer, I think we had a motion in limine for the jury trial, and Ms. Godwin, a motion to abate.
Yes, Your Honor.
Okay. Go ahead, Mr. Akhtar.
Okay, thank you, Your Honor. Good morning. I represent the plaintiff, Yolanda Brammer, who's the owner and landlord of this rental property in which Heather Godwin, a licensed and practicing attorney, is the tenant. This case is an eviction for non-payment of rent. Ms. Godwin has actually admitted in open court in a previous hearing when she filed the repair and remedy case, which got dismissed last week, that she hasn't paid for 4 months, June, July, August, and September. She has really engaged in quite a number of filings and motions, as you can see on the docket, doing everything she can to possibly delay this eviction hearing. That includes, for example, she made a request for jury, which pushed this eviction trial from 2 weeks ago to now coming up Monday, September 30th. The reason I filed this motion in limine is that the rules of civil procedure, 510.3, make crystal clear that in an eviction for non-payment of rent case, the only issues are rent and possession. So no other counterclaims, no other allegations or claims of repair and remedy, no other bringing up all kinds of other extraneous issues or joinder of parties is relevant, admissible, or even permitted. I mean, 510.3 is crystal clear. Yet, Ms. Godwin, again, being a licensed attorney who should know better, has made it quite clear in her filings and also in her communications to me that she intends to tell a bunch of wild stories to the jury about how she's been abused and sexually trafficked by the music industry, by APD, by FBI, by Facebook, Meta, by other attorneys, by other landlords, and now she's trying to lump my client in with this alleged global conspiracy. And this is the kind of story that she wants to tell to the jury. She also wants to talk about repair and remedy and how there weren't adequate locks on the facility, and this allowed strange men in a black truck to come in and implant new cameras and monitoring devices in the home. Again, that repair and remedy case got dismissed because she admitted that she was unpaid on rent for 4 months. So the reason I filed this motion for limine is that I'm really imploring the court to have a standing order that lets her know that she cannot turn this jury trial into a circus show, because that's exactly what she wants to do, and bring up a bunch of extraneous, irrelevant, and inadmissible arguments in front of the jury and taint them. And I've included some exhibits. I've sent even more exhibits in addition to the ones that I included with the actual motion in limine that show that that's exactly what she wants to do and that's exactly what she intends to do. She's making no secret about it. And I can go through some of those exhibits, Your Honor, if I can share screen, or if you already have a pretty good handle on it from the exhibits I attached to the motion, that's up to you.
So the things that you're seeking, there are 5 of them. Number 1 is that defendant be prohibited from bringing up any testimony related to surveillance, exploitation, or trafficking through the music industry, her father, her ex-husbands, her landlords, including and especially the plaintiff. That's 1.
Correct.
All right, Ms. Godwin, how would you respond to that request?
Okay. Just getting my paws in already. I'm telling you, these claims are wild. And again, I don't know. I'm not a part of the music industry. I'm not an attorney. Just on face value, it just seems way too wild to be true. Am I alone in that? Maybe the music industry is like this. We're watching I don't even want to say his name, but the one former really big music artist going through a bunch of stuff that just wow. So who knows? Maybe she's tied up in all that, or I don't know. But a lot of it just sounds crazy.
Your Honor, my answer was that Miss Brammer is not evicting me because of non-payment of rent. Miss Brammer is evicting me because I'm hiding my nudity from the cameras in the house and resisting their surveillance in that fashion. Because my resistance to the surveillance on social media and through the legal system have been to no avail. So I resorted to
Ms. Godwin, if the landlord was to make a motion for summary judgment and provide me, or summary disposition, because we're in justice court, and provide me with a ledger that indicates you have not made payment in full for the last 5 months, would you have factual evidence to support or disprove that there has been no payment made?
I would not have factual evidence, but I would have factual.
Ms. Godwin, if what you're doing is giving a reason why you didn't pay, that would strike me as not a defense. For the issue of non-payment, there is no acceptable reason under Texas law for you to not pay.
Understood.
So if what you're saying is that it's not about non-payment, my first question would be, can you prove that you paid?
No, I cannot prove that I paid.
So if Mr. Akhtar was to seek and say, Judge, there is no dispute of fact here, she hasn't paid, and because she hasn't paid, we have the right to an eviction, would you have any evidence to contradict that?
I would not have evidence to contradict that I paid rent, that I did not pay rent.
Okay. All right. Second one is about failing to repair or remedy. Third one is about owning other properties, selling properties. Number 4, defendant has a counterclaim or case pending. Counterclaims aren't allowable for an eviction, so you're right, that wouldn't come up at all. Mentions of other claims, counterclaims are things for it. All right. All right, well, plaintiff's motion seems merited, so we would grant the motion in limine and we will issue such a thing. Now, Ms. Godwin, though, you have a motion as well, and yours is about a motion to abate. So give me information on that one.
In the repair and remedy case, Judge Meeker, who is visiting judge for your seat, she stated that she agreed with me that the issues surrounding the repair and remedy case have too much gravity for a justice of the peace court, and she told me to seek my damages in a court where my damages are unlimited. So my position is that the repair and remedy case and the eviction case are already considered in the Travis County District Court case D1GN 24004818, Heather Godwin versus Yolanda Brammer.
Okay.
Ms. Brammer is using this eviction as a tool to coerce agreement to a music industry standard in this city where artists are abused. And that is the subject of my case in district court.
Okay.
track.
Unfortunately, Ms. Godwin, I can't abate the eviction in our court while the case is being heard in district related to the other topics between the parties. And that's because the exclusive jurisdiction for evictions resides with justice court. In fact, even the district court can't demand that I send the case to them. They don't have that authority. So it has to remain with us. So for that portion of it, it would have to be a motion, it would be denied. But after the hearing is held with the jury trial, you always have the right to appeal. Mr. Akhtar has the right to appeal. And then it would go to the county court. But again, they only get jurisdiction once it's appealed. It still remains with us. And that's true regardless of the amount in subject matter controversy. All right.
At that point, the county court determines more equitable issues surrounding the events.
The county court, if you appeal it, the county court becomes the jurisdictional court, but they still have to apply the standard Texas property court rules. So you don't, like, rules of evidence don't kick in at that point. The jurisdictional limit doesn't increase at that point. It still remains. It's just you get it's de novo. So there's no court of record here, and either Shepard or Wong or whoever is visiting for them would hear the case brand new.
Understood.
All right. Well, I think that takes care of any other pretrial matters, because we've gotten eliminate, we've gotten the motion to abate. We are set for our jury trial. Just for both of y'all, some information, since you're both counsel, this will make sense to you. We'll typically summon between 22 and 24 potential jurors for that. We almost always get at least 20, so we do successfully get a large panel to do it. Each of you will usually give 20 to 30 minutes for your questions for jury selection. You each get 3 peremptory strikes. Of course, you have an unlimited number of 4 calls, so you can always prepare those if you like them.
All right, while Judge is going through this, what do you guys think? Do you guys buy her story? Do you not buy her story? This is an eviction case, right? And the attorney for the plaintiff is just simply saying all these matters that you're bringing up, it doesn't have anything to do with this eviction case. You haven't paid rent. You admitted to not paying rent. That should be straightforward. You're bringing in a jury to decide whether or not you paid rent or you didn't pay rent. All the things that she's claiming should be in a different court, which is what I think should happen. If these things happen, even if a small portion of these things happen, she should be suing in a different court. That's just my opinion. Should have nothing to do with the eviction case. She should have been paying her rent. I mean, bottom line, you're being evicted for a non-payment. It's not hard to prove. Okay, let's finish up this clip, and then we're going to get into the bonus clip, which is part 1 of this hearing. By the way, the bonus clip is the case that they keep referencing in front of the other judge, but there's a reason why I added that a bonus at the end, and I'll get into that here in a second.
Rules of evidence don't apply. If you've already submitted all of your documents, we have those so we can screen share them in the courtroom using our click share device. If you want to bring additional things, you can always bring print copies, right? Especially if you want something to be able to go back with the jury. We make it available, but we'll never be upset if you bring a copy for them. And then the other thing is, if you were going to bring a laptop or a tablet or an electronic device, and you want to be able to share things from your device to the courtroom, the method that we use for that is a little plug-in device that is a USB port. And recently I've had attorneys, you're getting fancy new computers that don't have a USB port on them. So just be cognizant of that if the device you plan to bring doesn't have a USB port, you need to submit through e-file or email the night before all of the exhibits, because we wouldn't be able to let you use the method we have. All right.
Your Honor, just one thing. Since you brought it up, and I really would like to spare 24 unfortunate souls from having to come on Monday. If I can urge the motion for summary judgment now, I don't know if it's possible for it to be heard now. We have all the evidence. I don't know if it could be heard before the trial. I'm just trying to avoid, I mean, there's been a lot of waste of time and resources from Ms. Godwin's multiple filings on this case. And she, of course, has that other case going on in district court, which we're going to hearing on next week.
All right, well, we actually have 3 cases set for jury on Monday morning. So even if y'all resolve this, or Mr. Akhtar, if you make a motion that morning for disposition and it's granted, our jury, all 24 jurors are still going to have to come. So I appreciate that. But right now, y'all have priority on the docket. So we have 3 trials set that morning. Of them, 2 are evictions. 1 is a civil standard contract dispute. The order would be preference for y'all's case, and then if it doesn't go forward, the other eviction, if that one doesn't go forward, then the just plain old contract case, they get the jury pool. All right.
Okay,
All
but
right.
it does sound like we do have the option to file the motion and have it heard that morning, is what you're indicating.
Yeah, I'm on both parties. Y'all can follow the motions. We just hear them that morning. I'm not going to rule on it right now.
Okay.
But
All right,
yes.
thank you.
All right then. All right, we'll go talk to both of you. If not, I will see you guys on Monday.
All right, thank you.
Leave early. They're beginning construction on Highway 71 too. If you haven't been out here to the courthouse in a while, you know that the Y is always under construction, but now they have begun the official expansion of Highway 71 directly in front of the court. It's often shocking to people, but add 10 minutes to your commute, okay?
Thank you.
All right, just
Understood. Thank you.
practical information about accessing precinct 3. All right, well then all parties to that matter are excused. Thank y'all.
Thank
Thank
you.
you.
Goodbye.
And Monique, that does conclude our matter.
All right. Now, this is the bonus clip. This is the previous hearing that happened, I think they said 2 weeks before this one. And here's the reason why I made this a bonus clip. It's just factual information for, to follow up on, or I guess it's not really following up on. It's a prequel to everything that was stated every time they mentioned the previous hearing. This is where this comes from. It doesn't add a lot to this case. It just shows you that everything they said was correct. But here's the reason why I didn't put this, before. There is a very annoying high-pitched noise going on in this courtroom for whatever reason. No idea what reason it is, but because I just showed you the gist of what's going on, you guys can exit the video now. But if you want to see the prequel, I have it. Just you might not be able to make it through the high-pitched noise. It's annoying to me, and I'm half deaf. So that's my warning. If you want to dip out now, fine. If you want to watch the first couple seconds to see what I'm talking about, that's fine too. But
Yolanda.
Oops, accidentally just hit play. But you guys, but thank you so much for watching. If you're dipping out now, make sure you hit that like button. I would appreciate it. All right, let's go on with part 2. Or I guess part 1.
Brammer? Repair and remedy case?
Yes, Your Honor, I'm here. Heather Godwin.
Okay, Ms. Godwin, you're here. And we have Mr. Akhtar.
Yes, Your Honor, representing Yolanda Brammer, and Yolanda Brammer is also here.
Okay. Excellent.
I'm here.
Okay, excellent. Ms. Goodwin, you filed the repair and remedy case. Is that correct?
Yes, Your Honor, I did.
Okay, let me swear you in. Do you swear to tell the whole truth and nothing but the truth?
I do.
There's also an eviction case pending against you, correct?
Yes, Your Honor, that case is going to be heard by a jury on September 30th.
Right. So there's at least an allegation that there's rent outstanding, correct?
There is rent outstanding, yes, Your Honor. There's
And-
also a district court case for a trafficking issue.
Mhm. Usually repair and remedy cases, they apply to situations where there's not rent outstanding.
Yes, and that's my question for the court. I am actually a family law attorney, so I'm not well seasoned in landlord-tenant law.
Uh-huh.
And there are 4 months of rent delinquent. Miss Brammer has accepted extensions from me in the past. I have a large attorney fee coming to me at the end of October.
Uh-huh.
And she also told me when I'd fulfilled the rent obligation after an extension, and I have text message proof of this in my exhibits. When I had fulfilled my rent obligation after an extension, I told her, thank you very much. I don't want to get kicked out, and she told me that I'll never kick you out. But that's as to the delinquents, whether the rent is delinquent or not. But my question is to the court is, even if the rent is delinquent, the statute provides that if the rent is delinquent, then that creates a defense to a repair and remedy case. But the statute, the section does not phrase it in a manner that creates an absolute bar. Of course, it is a defense to a repair and remedy case, but in cases where there are punitive damages being asked, in cases where the landlord's gross negligence creates a situation where the actual damages are, over $1,000 in medical bills. In cases where it's extenuating circumstances create damages, actual damages, and punitive damages, basically, is the defense an absolute defense to a repair and remedy case? Is the defense of delinquent rent an absolute defense? The statute is not written with a shall. The court shall not grant, award damages in a case where a tenant is delinquent. The code is not written to a tenant must be current in rent in order to bring a repair and remedy case. My question for the court is that defense an absolute defense, or is it a consideration in defense for the landlord?
It's pretty much you have to go sue in a different place. You just got to do it another way, the way we look at it. Okay.
That's happening. I appreciate.
That's just kind of, and I'm certainly not saying I'm an expert on all of this stuff. I mean, you can read it as well as I can, and it simply says that the tenant is not supposed to be behind on the rent. I'm trying to the duty to repair. And I've got 92056.
Understood, Your Honor. I just need a clarification for the court. No argument.
There's lots of ways you can get what you want.
That's in the works.
I'm sure it's in the works. It says that the tenant was not delinquent in the payment of rent at the time any notice required was given. And I think we're just trying to weed out the cases where the tenant's trying to kind of insinuate a reason why they were late in the rent and get it all mixed up. They want everything nice and smooth, that they're really talking about things that materially affect the condition, and that there's no dispute about rent.
And I also believe that the gravity of the case, it's more appropriate to be heard in a district court. That's just what I feel.
Right. That is true, because with the de novo appeal, it's all going to go to county anyhow and be reheard with the record.
Right.
You might as well go where your damages have no limit, where you can really sue for what really happened, and you can get as much as, not just be limited at 20,000.
I appreciate that comment, Your Honor.
And I don't want to say, it's not like I don't want to hear your case or anything.
I'm fully aware, and I'm not taking it personally or daunted in any way, shape, or form.
And so that's my consideration, is typically we don't, if there's rent involved, we don't hear these cases. We say y'all need to find a different way to get what you want.
Thank you for the clarification.
Okay. Mr. Akhtar, do you have anything to say?
Okay, so I guess I just want clarity. Is she dismissing or non-suiting her case, or?
I'm just going to dismiss it. I'm
Okay.
just going to say it's dismissed.
In that case, I won't waste any of the court's time.
Okay, well, thank you very much for appearing, and I'm sorry y'all had to wait through all the evictions. That's just the way the docket goes.
All right, that's it. Again, if you stayed through that, then you guys are saints. I do appreciate the watch time if you did, but I do understand if people dipped out. That high-pitched noise is very annoying, and now you know why I didn't put that in the main part of the video. So if you're still here, thank you so much. I do appreciate it. And if you haven't done it already, please hit that like button. I'm going to let this video play out. There's only a couple seconds left. You guys have a great day, and I will see you next time. Until next time, bye.
Judge Holmes prefers that cases that are disputed be heard first. then we can go to the no-shows. So I'm sorry y'all had to wait so long.
That's
Alright.
fine.
Thank you.
Thank you.
For appearing, and I hope that y'all have a pleasant day.